Good evening, everybody. Welcome back for another edition of Reasonable Doubt, brought to you by the Harris County Criminal Lawyers Association. I'm your host, Jimmy Ardwan, and my normal co-host, Julio Vela. He is lounging somewhere on a beach, drinking a Mai Tai. So, filling in for him this week, Kate Farrell.
Oh, well, good evening, everyone.
You're usually hiding behind the booth.
That's where I prefer to stay, honestly.
And here you have come out to grace us with your presence.
Well, you're welcome this one time.
So this is our one and only time.
Yeah, it is. Make it worth it.
Okay.
Famous last words.
Yeah, I've heard women tell me that before. So, Badoom Bob, right? So Kate's going to join us for the next hour here, along with our guest, Troy McKinney. Welcome back.
Always happy to be here.
We're glad to have you on. And Jordan Lewis.
Hey.
It's been a while.
It's been a little while.
So we're glad to have you back as well.
Thank you. Thanks for having me.
We'll be with you guys for the next hour. We'll be talking about gardening tips and other nice little things that we can help you out with now. We're going to talk about criminal justice because we got a lot going on. And we'll open up the phone lines. Hell, we might even open them up now. 713-807-1794 if you want to get on the conversation. We also have Twitter up at HCCLA_TV. So let us know your thoughts, your comments on the discussion we have going on here tonight. A lot of stuff going on this week, guys. Let's start with, I want to talk about this case that I know has caught you guys' attention, because I think it directly impacts kind of some of the political promises that were made with our DA's office, and a long-standing gripe that we've had on this show, and as the defense bar and whole, and that is Brady violations. For those that don't know, Brady violations, as we like to call them in the lingo, is when a prosecutor fails to turn over exculpatory evidence for a defendant. And this recent case that just came out in May of this year deals with a DWI case where exculpatory evidence was not turned over.
Well, I just want to say that it's not just exculpatory evidence, it's impeachment evidence.
True.
And in this case, it really doesn't go to exculpatory per se, but the impeachment of that person as an expert. And that's really, really important when you're dealing with pretty much any expert. And so that's what this, and I'll let Troy talk about that more, Jordan, obviously. Sure. But it really goes to the impeachment part of Brady evidence.
Yeah, because
second part.
Right, because it technically is exculpatory if you're able to thoroughly impeach a witness. Yeah. It can exonerate your client. Mm-hmm. This case dealt with DWI evidence, specifically blood evidence. Now, we've all tried DWI cases around this table. You three have tried way more than I have. I can guarantee you that. But this was a blood test, and I believe it was a .193, if I remember correctly. And there were some allegations, and feel free, anybody jump in if I get something about the factual recitation wrong, but and there's some comedic parts about this too that we definitely need to touch on. But the lab analyst who testified at this trial had a disciplinary issue that apparently they did not make the defense aware of that. Dealing with maintaining records, falsifying records, I believe, in some instance where...
It's not maintaining or falsifying records.
Right.
She had switched vials in a sample, and she had been taken out of doing active casework. And one of the issues became whether being taken off the front line of doing active casework was something that resulted in a suspension or not. And frankly, whether it was a suspension or whether it was just being taken off active casework, either way, it was information and data and facts that affected her credibility on whether she was competent to analyze the sample, competent to report the results, and the information wasn't disclosed.
Well, and I want to say that, and sorry, I'll let you jump in. I just want to say, there's issues with this particular analyst, but I don't think she self-disclosed. She was very honest about her mistakes. Now, does that not relieve her of the fact that I think there's serious issues with her ability to be an analyst? I'm not saying that. Yeah. But as far as her honesty level goes, I think she was very honest in her mistakes. And so I'm going to at least give her that credit.
And the problem here was with lab management.
Yeah.
It's all over the opinion. The manager of the lab at the time, Will Arnold, who was I think by this time the lab was already quote unquote independent from HPD, but Will Arnold was definitely one of the carryovers from the HPD crime lab and all of that fiasco. But once the analyst's problems came to light, Will Arnold made a conscious decision not even to tell the DA's office that he had prohibited her from doing any further blood analysis until they got all this sorted out. When she took the stand and testified, in this case, in the Diamond case, she was at that time not allowed to do any blood analysis. Will Arnold was sitting in the courtroom watching her testimony, and immediately after trial documented that her handling of her testimony indicated that she didn't understand the basics of what she was supposed to be doing, why she was supposed to be doing it, why any of it was important. But he made a conscious decision to keep it to himself, and I think the quote in there was to protect her from having to deal with an uncomfortable cross-examination, which is precisely why they're required to turn it over.
Yeah. Well, and hold on. If I could back up, I think we need to give the audience a little bit more fact information.
Let's do that. This was a DWI trial where the arresting officer had made many mistakes, had admitted to many of those mistakes during cross-examination, so much so that the prosecutor in the closing arguments basically conceded that the officer was unqualified and incompetent.
Called him stupid.
Yeah, it was like dumb and simple.
Yeah.
Simple or slow or stupid, whatever you want to call it.
And so in the context of that, you can be convicted of DWI either because of the things the officer does on field sobriety testing or because of the breath or blood alcohol level, in this case blood. And so the blood alcohol level became a central issue in this case. And the prosecutor argued in the end that all that really mattered in this case was that number. The competency, the effectiveness, the reliability of that number was all that mattered, and that they should decide the entire case based on that. And in the context of this, and in fairness, the prosecutors at that time in 2014 did not know this information.
Right. Well,
it had not been disclosed to them.
Okay, well, but let's just make sure we understand what we're talking about when we say that, because although they may not have actual knowledge,
let me finish.
Yeah, okay,
let me finish.
Sorry.
The trial court prosecutors who tried this case did not know that the analyst had been effectively suspended from doing casework at that time. The lab supervisor knew, the analyst knew, and neither of them disclosed. They are both state actors. They are both part of the legal prosecutorial team, whether they consider themselves to be or not. None of them disclosed that to the prosecutor. None of them disclosed that to the defense. It was not disclosed. And having said that, what raised this issue later was that long after this trial was over, and the story about what had happened with her and her misdeeds, her mistakes, however you want to phrase them, and her suspension or her removal from casework were raised was long after this trial was over. And so this case arose, and the litigation over it arose after that was disclosed during the current administration of the district attorney's office.
Yeah, so procedurally, I mean, they had the trial, I believe it was back in 2014.
It was.
The case goes up on appeal, I think, originally. The appeal, the case
There was
is...
no direct.
There was no
There was
appeal.
no direct appeal?
There was no appeal.
Okay. You guys know that they just went straight to a writ proceeding.
Well, that's correct. After the information involving the analyst was disclosed, the defendant apparently hired a new lawyer,
Right.
Josh Schaefer, who did an outstanding job on this, and they filed what's called a writ of habeas corpus. That's a proceeding where they challenge the validity of the underlying conviction based on, in this case, the denial of this Brady material, this exculpatory evidence. It was not disclosed at the time. And it doesn't matter legally whether the prosecutor knew about it or somebody else associated in the government knew about it. It wasn't disclosed. And they raised this issue, and the trial court heard the case and decided for a variety of reasons that it didn't matter and wouldn't have affected the result and denied relief. And the Court of Appeals ultimately, in reviewing this case, and this is what just came out, the Court of Appeals heard this case and ultimately said, absolutely not. This was clearly suppression of evidence that was useful for impeachment of this witness on the witness stand, that both Will Arnold and the analyst hid this evidence from everybody, prosecutor and defense. And the problem here isn't so much, well, there's two problems. One, they did to begin with under the prior administration. The second is that the current administration defended this practice.
Yeah, I want to drill down on that a little bit because you just, and I kind of want to help people understand more of the procedural aspects so they know how we kind of got to this point, because obviously this case was tried under the old administration. The failure to disclose was not done to the old administration. I don't even know whether the prosecutors who tried this case are still even with the office today or not.
They weren't named in the opinion.
Yeah, they weren't named in the opinion. But so at some point, I mean, I think people need to understand because, you know, you guys just told me about this, so I was kind of quickly skimming it. And I understand, I thought that there might have been a direct appeal, but there wasn't. Do we know when exactly the lack of disclosure, when did they get that evidence? What year did they finally figure out, hey?
The hearing for the hearing on the writ of habeas corpus was
Well, I'm not talking about that. I'm talking about when did they learn? When,
Well,
It was,
this is
yeah,
it was sometime in mid 2016.
Okay, so almost 2 years later.
Right. Now, Kim Ogg was not yet the district attorney when the writ of habeas corpus was heard in the trial court. But by the time it went up on appeal, she had taken over, and we've all seen
Well,
cases.
Why does it take 2 years, though,
so-
to learn about
Hang
it?
on,
Well,
are you
if
sure
I can,
about that?
if I can add, I think it was actually, I thought it was 2015. So because Andrea Gooden did a self-disclosure to the Texas Forensic Science Commission. And so they did an independent investigation.
Tell the audience what a self-disclosure on this means.
She went to the Texas Forensic Science Commission and said, "Hey, I made a mistake. Here's what I did. Here's what we did in response to it," so
Yeah.
that they could investigate and determine whether the lab had in fact made a mistake, and if so, whether they had handled it appropriately.
And Texas Forensic Science Commission, in and of itself, is a body that, by statute, reviews labs. Maybe you guys can talk a little bit more about their place in this kind of hierarchy. But they review labs. They make sure they're, you know, abiding by their accreditations. Make sure and it is the place that you self-disclose to, I guess. And so they can do independent investigations. And so she did do that self-disclosure. The Texas Forensic Science Commission did their investigation. It was during this investigation that a lot of this came to light, and that their report was made available, and that was when that report was made available to the district attorney's office, if I'm correct.
Right.
Right. And so that's when this was kind of learned. So I thought it was more 2016, 2015, but I could be wrong on that.
And it may have come to light in 2015. I thought I recalled seeing that and I may be wrong, but I thought I recalled in the opinion seeing that the actual hearing on the writ of habeas corpus in the county court was in 2016, shortly before the election.
So I think the writ took place a little after this. So once that report was made available, defense attorneys were made aware that this issue happened. The writ relief is still available, even in these cases where you take probation or something like that, because you're still suffering the legal consequences of it. And so a writ of habeas is still available to you. And so she's still suffering these legal consequences. That writ relief is still available. But I think you're right on the writ itself was 2016, but I think the disclosure to everybody was 2015 through the Texas Forensic Science Commission.
Okay. And ultimately, regardless of when the dates were, the writ was denied by the trial judge.
It was.
I thought it was after that, but maybe it wasn't. But regardless, there was an appeal then by the defendant to the Court of Appeals on the denial of relief on the writ, and the argument was the trial court should have granted us a new trial on this because of these events. And regardless of when the writ hearing took place, and this is personally for me, it's the sad part about this, is that the current administration has continued to defend this on appeal.
Yeah.
Right.
So it looks like, and I'm reading the original writ. If Josh is watching, he can call in and maybe correct my interpretation of his writ. But it looks like General Counsel for the DA's office notified people in the office of all these problems in February of 2015. And still it was not disclosed to the defendant.
Well,
Yeah.
the trial was in 2014.
Correct.
2014. She self-disclosed later on. I believe it was. This all occurred in January.
The dates on this are beside the point at this point.
Yeah.
Yeah, I mean, but it
they-
just goes to show that how long it's taking the process. I mean, someone here
Yeah.
is convicted. They didn't get all their evidence. I mean, over a year later, there's an email that's sent out notifying everybody, and then it takes the defendant doing some digging to figure out, oh wait, or the defendant's lawyer to figure out, hey, I didn't get this crap.
Well, this is the bigger problem in these types of cases. It's not up to the DA's office. It's not up to anybody but the defense attorneys or the defendant, depending on the defense attorney. Nothing being said, but. To really go in there and investigate. We had Kenneth Truce, that DWI officer who lied about multiple things. And it took defense attorneys going in, figuring out, okay, wait, was this case a part of this? And doing all that digging, because none of that's being released, even though the ones in the best position to tell whether that case is affected or not is the DA's office.
Some people are going to say, what material effect did this actually have on her trial? Because it has nothing to do with the actual blood results.
Well,
Actually, it does.
Well, I'm
Actually,
wondering
it
because a
does.
lot of people may argue this doesn't have anything to do with it.
The first thing it has to do with it is the analyst's competence in being able to accurately place the vials in the slots they belong in that they're tested. She had admitted to switching vials. Beyond that, the fact that the lab thought that error was significant enough to remove her from active casework at that time and keep her removed from casework until it was investigated and resolved should have been disclosed. If you have a lab analyst on the stand and the validity of the blood test is at issue, as it was in this case, the fact that analyst is currently suspended or removed from casework is a material fact that if I'm on trial, if I'm a juror, I want to know that. Because that gives me a reason to doubt the validity of the work they did. And that's why it had value.
And in addition to that, and partly because of this, but also partly because of some presentations she made, intra-office presentations that she made, testimony from other cases, her supervisor wrote that he had grave misgivings about whether she understood what she was doing and knew what she was doing. And in a case where the blood test evidence is in question, if you're going to present expert testimony, you have to present experts who are qualified to give that testimony. And it sounds like within the lab, they had questions about whether they thought she was qualified, but they kept presenting her to testify without sharing any of those concerns with anybody. And any competent criminal defense lawyer, that's going to be one of the first lines of attack, is the competence of the person who did the testing. Because if they're not competent, you can't trust their test. If you can't trust their test, that number is meaningless.
The reason that mattered in this case was because the result was above a 0.15. Whether that result was reliable to be above a 0.15 was a critical, crucial element that the state had to prove. And if the jury had a doubt about the reliability of that number, then they could not have convicted this defendant based on being above a 0.15. Look, we're kind of missing the ultimate point here on what the Court of Appeals did, ultimately, I guess yesterday.
We're just slow to get to it.
We have been very slow to get to it.
We're meandering.
The Court of Appeals in this case, I'm not going to go through the background of how they got there, but ultimately they got to the point where they decided that the state, the government, which included both the prosecutors who knew nothing about it at the time it happened, but the lab people who were agents of the state, hid this material evidence that should have been disclosed, that should have been useful at trial, that may very well, in the Court of Appeals' opinion, influence the outcome of this trial and may have resulted in a different verdict in this case because it was not disclosed, especially given the fact that the underlying arresting officer apparently did so poorly on the stand that even the state characterized them as stupid and dumb in their closing arguments. And my concern today, we can't fix what happened a long time ago other than to give somebody a new trial, which the Court of Appeals did. The current administration, Kim Ogg, and I love her to death, ran on a platform of, we want transparency. We're not going to allow people to hide exculpatory evidence, and this office has been wonderful about disclosing things that are even close to being exculpatory. The fact they are continuing to defend the denial of that in this case is troubling and problematic.
Right. Yeah. We've seen cases before where the state of Texas looks at a case and realizes, hey, that guy is right. He's entitled to a new trial. We screwed up. You can confess error in the appellate court. If the concerning thing here is that if this administration was serious about these sorts of issues, there was nothing stopping them from going to the Court of Appeals and saying, Judge, this defendant is right. She should get a new trial. She was entitled to know this before her trial. It was kept from her. We didn't do it, but she's entitled to a new trial. We will agree to the relief. And instead, they've defended it all the way up to this point, and it looks like we've got some phone calls.
Cool.
Hey, that's my job, not yours.
Sorry, man.
That's because you can see the screen and the rest of us can't.
I was going to say it even goes outside of this,
Ryan,
this
you're
particular
exceeding your
case,
scope
though.
of duties here.
Well, and correct me, maybe y'all disagree with me on this, but I feel that this goes outside of this case in the fact that Will Arnold is still employed at this lab. They knew there was issues with him. He's now been, he's not overseeing the toxicology area, but he's seen the evidence handling area. And I think that's an issue. Andrea Gooden is no longer just an analyst, but she's an expert reviewer in these cases. And none of this has been brought to light. Nobody's talking about this until this case happened. And yet these people are still employed there, still doing very high-level jobs. And yet, where are we left at as a defense bar?
Will Arnold has played a central role in every crime lab scandal I can recall since I've been a lawyer. I was on this show 7 or 8 years ago now, right after the Culbertson mess, and he was at the center of that mess as well, and he's still employed by the lab that no longer has anything to do with HPD.
Well, maybe he's calling in to talk to you.
Maybe so.
Oh, that'd be great.
Let's see who it is.
Let's see who it is. Hello, thanks for calling Reasonable Doubt.
Hey, I have a question. I think Kate did a good job of summarizing what Brady evidence is, impeaching evidence as well as exculpatory evidence. But my question is for Troy, can we read that into the Diamond opinion based on the procedural posture of the case? In other words, the writ is appealed, that decision's affirmed, and then they realize the judgment is incorrect, do a nunc-pro-tunc, and it goes up again on rehearing, and that's when they withdrew their opinion and reversed it. So does that limit Brady's application to impeaching evidence?
I purposely avoided talking about those procedural things because they don't really matter to the issue we're talking about. There were some mistakes in the paperwork that were cleared up that resulted in the current opinion, and those mistakes really have nothing to do with the Brady effect, except to the extent that, and this is what I talked about a minute ago, that an element of the offense that the defendant was prosecuted for and convicted of was a result above a .15. And that's where the Court of Appeals ultimately came down and said that given this evidence, the jury may very well have had a doubt about the reliability of the testimony to the extent that they had no confidence in the outcome of the trial and in the verdict because of the exclusion of this evidence.
At what point, are we ever going to reach a point where we're going to have a consensus on what is Brady material? Do you ever get to that point?
Well,
a consensus? The court decisions are very clear. There's no question what it is.
okay, well, hold on. Wait,
I know the
question.
courts have said that, but I'm
No.
talking about in a day-to-day.
And in fact, I'll give the state credit for this. They have conceded on appeal that this should have been disclosed and turned over. They never challenged that. They agreed with that. Their ultimate argument was it made no difference to anything.
In the result.
And that's the problem here is that the promises of this administration were we want to respect the integrity of the process. These things matter. We don't want people convicted where material evidence that should have been disclosed hasn't been disclosed. And that happened here. And regardless of whether this administration was there when the red hearing took place or now, this administration, in my opinion, should have said, you know what, there was a mistake. we're going to fix this by giving this guy a new trial.
Right.
It's not like he walks free. We're going to give him a new trial so it can be done the right way, so we have confidence in the process that got to a guilty verdict before you affect somebody's life in a way that will affect them for the rest of their lives.
I think too many prosecutors look when they're determining Brady whether something is Brady evidence and must be disclosed, and specifically whether it's material. I think a lot of the problem is the very first question they ask themselves is, well, do I believe this? And that's not that's not relevant. The issue is, if a jury heard this, could it affect the verdict? And I think the rule ought to be that if it makes the prosecutor go, then he needs to turn it over. I don't know where, in terms of their training, this idea that if they don't believe it, it's not material is coming from, but that's something that well, in talking to prosecutors and in looking at how they defend decisions not to turn over material that should have been turned over, that seems to be a huge part of it. If they don't believe it, it's not material, and so I don't have to worry about it.
Well, and I think in this particular case, though, I really don't blame the prosecutors. I don't think they had any knowledge that this was happening. I don't think they have any awareness. I mean, the fact that you even think they understand blood discovery. I mean, it now legally, they of course do. I mean, they are, the analysts, the lab are agents of them. So legally, absolutely they do. But what I'm saying is like actual knowledge. I don't think they had actual knowledge that this was occurring. So I'm going to let them off that tiny little hook. The other Brady things that I think is interesting, and something I've had conversations with Troy about, and I know Troy has talked about, is the kind of going to a bigger picture of what Brady is we like to call it trial Brady. And I think you've spoken about this. Like, I don't think there is, I think it's all Brady. I don't think there's a distinction between Brady and trial Brady, but I think you, and correct me if I'm wrong.
It's not me that's spoken about, it's the U.S. Supreme Court who's
Okay,
spoken
there we go.
about. There are.
Talk about that.
We sometimes confuse you with the Supreme Court.
Well, I wish that was true.
You're our local Supreme Court.
There are two parts that matter to this. There's what I call core Brady, which is evidence that affirmatively establishes somebody's innocence. Mm-hmm. This evidence is not that. Yeah. This evidence does not affirmatively establish innocence. And then there is evidence that has impeaching value for a witness who may testify. And the U.S. Supreme Court has clearly said that evidence has to be turned over. That is also Brady evidence. But it only has to be disclosed sufficiently far in advance of trial to be useful at trial.
But see, that's a toothless tiger. Because, yes, they're saying that, and they've said this over and over again, but every time you get an opinion like this, there's no sanctions. There's no teeth in it for if they don't turn it over. It's like, yeah, okay, you get a new trial.
Right.
But that doesn't stop the problem from happening. It still continues to happen, and these guys still go up and argue, well, but it's not material. I mean, they don't change their argument.
And that's my disappointment in the fact that the appellate division of the DA's office has continued to defend this case even after conceding that this evidence was material. If it wasn't material, it wasn't Brady. And they conceded it should have been turned over, which implies a concession that it was material. But they nonetheless continued to argue that it wasn't material and wouldn't have made a difference. And the Court of Appeals emphatically and clearly rejected that.
Yeah.
Well, and
something else to add?
the Supreme Court has said that before you enter a guilty plea, you don't have any right to be told about impeachment evidence. Your right to know about impeachment evidence about witnesses is attached to trial, and they only have to give it to you far enough in advance of trial that you can put it to effective use. And so a real question I have is whether this Court of Appeals would have been just fine with it if they had told them the morning of trial, oh yeah, hey, by the way, she's not doing bench work right now. There were some issues with labeling, and she's not doing that stuff right now. Do with that what you will.
Well, that was going to be my next question with having you two here. What is far enough advance in trial? Like
that's always fact dependent. That varies from case to case. Mm-hmm. Some parts of this you could have learned on the morning of trial and used. The mere fact that she wasn't doing casework could have been used during trial. The mere fact, whether you call suspension or just removed, whatever label you want to put on it, that could have been effectively used in trial. The underlying details of what happened, the Forensic Science Commission took months to investigate that. That part of that could not have been effectively used with a short before trial notice. So whether the notice is sufficient matters based on the individual facts of the case. And a good example of that is the Temple case that Kelly Siegler had, where things were actually disclosed during trial, and some right before, but a lot of it during trial, where the court said, even when they gave them a continuance during trial, it was not enough time to effectively use it because it affected the way they approached the whole case.
And if you don't mind, can you just tell us, either one of you, just kind of a little bit more about the Texas Forensic Science Commission? Because I actually think it's a really important body. They investigate so many different areas of the crime lab, and their investigations can be really important. They air it live. You can watch their meetings. If either one of you kind of want to take that.
The Texas Forensic Science Commission is composed of a variety of people, which includes people in the forensic science community. It includes people that are political appointees. There are prosecutors, there are defense lawyers, there are judges, there are people involved in the process. There is a representative that the Texas Criminal Defense Lawyers Association, well, let me rephrase that. TCLA gets to give the list to somebody, maybe the governor, of 10 people, and the governor picks one of those people off the list. So there is a representative from that group. Its goal, its purpose, is to investigate allegations of problems, of lack of compliance, of potentially bad science from whatever cause in crime labs. They don't get to determine whether these results matter to a case. They simply evaluate it based on whether what was done should have been done or it should have been done differently, whether things were hidden, whether there were bad forensic practices, and they release reports ultimately on those decisions.
Yeah.
Well, I think we beat this topic.
Cool, let's go on to something else.
Let's talk about the thing that's getting a lot of attention nationally, and that is this Dallas police officer, Amber Geiger, who came home from her job, finished up her shift, comes
Allegedly.
home. Yeah, there's a lot of alleged things in this whole thing. Let's just start with that premise, okay? The main story that's being floated out there is that she comes home after a late shift to go into her apartment complex. If you believe the story that was in the arrest affidavit, apparently she might have mixed up the floors, goes to what she thinks is her apartment, puts I guess they have one of those electronic key fobs to open the doors, not a normal key.
There actually was a key that went in, but it said light off.
I thought it was a fob situation where she stuck it in, kind of like one of those hotel things, and when she stuck it in, it opened the door. At least that's what I understood the affidavit, how I read it. But anyway, the door is partially opened, at least according to her version. She goes in, sees somebody in there, thinks it's a burglar, shoots him. Turns out, no, it ain't her apartment. It's his apartment. And he dies. She has been arrested. She has been charged. The case is, it's got multiple issues on so many fronts. Of course, she is a white female. He is a black male.
And she's a police officer.
This comes literally right on the heels of the conviction of the Balk Springs officer in Dallas County. It's setting up to be quite an interesting time in Dallas County for police-citizen relations up there.
Well, it's really easy to confuse a gun and an apartment, right? Like those are just interchangeable things that you confuse.
Yeah.
So.
Do you guys think, have all y'all read the arrest affidavit?
I've read the affidavit completely, and
Yeah.
here's my take on this. First, I am a strong believer in don't rely on media reports for what the actual facts are.
Right.
Always incomplete, often wrong. There are a lot of the early reports.
Some of us think the same thing about offense reports.
Well,
too.
that's true. And
Well, some
sometimes
people
that's true
think
as
that
well,
about
but-
that PC affidavit.
Yeah.
So there's that.
But don't rely on the media reports. And the same thing is true of the PC affidavit, the probable cause affidavit, which, as I understand it, was done by the Texas Rangers. Mm-hmm. If that probable cause affidavit, and I qualify that with an if that probable cause affidavit is factually true and accurate and complete, there's no crime here. If it's not complete, if there are other factors at play, then merely because it's written there does not mean it's true and accurate and complete. There may be other facts at play, and I think we're way too early.
Well,
in the
I don't
story
want to
to
be
reach a conclusion.
Yeah. Go ahead.
Sorry, I just don't want to be the person who's like, oh, I don't believe anything that's written. But has have any of us seen a PC affidavit written that way? Come on. Like, it was.
Well, here's the thing. If I've seen cases reported in the news, we see them come through the courthouse occasionally, of someone banging on the wrong door trying to gain access, and then the person banging on the door getting shot through the door because the homeowner mistakes him for a burglar. I mean, it does happen that people accidentally try to get into the wrong apartment.
Or the wrong car.
Or the wrong car. And other people who are unaware of what's going on respond as though someone is trying to break into their home. And, you know, I will say, I'm pretty sure that had this just been a civilian who carried and the exact same thing happened, we would not have been hearing about it in Houston.
Well,
it might have made the news in Dallas, but we would not be hearing about it if she was not a police officer. And I think that the fact that she's a police officer is something of a red herring here.
Yeah, because she technically was not a police officer at the time she was going into.
She wasn't on duty.
Right.
She wasn't on
Yeah.
duty, but she had a gun on her hip because she was still in uniform because she had just gotten off duty. But had she been simply a civilian who walked into the wrong apartment, saw what she saw, pulled her gun out of her purse and shot the man, the police would have been called. I'm not sure she would have been charged, and I'm pretty sure nobody outside Dallas would have heard about it.
This is my issue. We're all acting like what she did was normal in a police procedure. I don't even feel that. I was a female military cop. I carried a weapon on my hip. My first instinct when I walk into somewhere that maybe I'm not really sure what it is, you have other options. The fact that that PC affidavit kept saying he did not respond to like my verbal, signals.
Yeah.
Well, the first thing you're taught, and feel free to call in anybody.
Did you ever walk into what you thought was your own apartment with that gun on your hip?
I walked into a lot of situations as a military police officer.
Did you ever walk into what you thought was your own apartment?
The first thing you're taught is you're going to take cover. You're going to back out. Where is he going to go? What's going to happen? Your first instinct, the first thing you're trained to do is to back out, take cover. You're in a doorway. Why are you going to pull your gun in a doorway and act as if this is the right thing? That's not training. Training is to back out, take cover alongside the doorway, and then it's called doing the pie. That's what you're going to do. So even what her actions were, given the fact that she's a police officer, in my opinion, in my very humble opinion, are incorrect. You're going to back out, take cover, and then figure out what's going on.
I'm not yet ready to judge her actions.
I'm not judging. I'm just saying.
Well, you did. You said in your opinion you think they're incorrect. I'm not yet ready to judge that because we don't know the whole picture. And whether it's probable cause affidavit or the facts reported in the media, we don't have the whole picture. The one thing I am 100% confident of is that if the facts in that probable cause affidavit are the facts, they don't support a manslaughter charge.
No, I don't see how you. I don't see any set of facts based on any of the things we've heard that get you to manslaughter. This was either murder or not an offense.
Right. And let me ask you
I
this.
agree with that. I agree with that.
It's actually a mistake of fact.
Right. No. I mean, if she is telling the truth and she genuinely believed that she was walking into her own apartment and she genuinely believed that she had just encountered an intruder, then a reasonable person in her position would feel threatened, and she was defending herself in the face of a mistake of fact. That's not an offense.
Okay, so can I ask you guys a question?
She didn't accidentally
the fact
shoot
that
the
she
guy.
was a cop is irrelevant to the equation.
It's a red herring. It's a red herring.
So that was going to be my question. If we take it, everybody's kind of touting like, oh, she was a police officer, she's a police officer, and that's where I was going with like training. I'm sorry, I don't think that's your natural reaction. If you've had training in this area,
I think you're crediting the training a lot more.
I think civilian officers.
I
think civilian officers are trained to shoot first and ask questions
okay,
later.
so if you take out the police officer aspect, what are you left with? Somebody who walks into an apartment, thinks it's theirs, and then they pull their gun, right? So what does that leave you? If you take out completely that she's a police officer, where does that leave you?
Well,
it's either murder or it's a justified homicide.
The mistake of fact law says that if a person, by reason of mistake of fact, as a result of that mistake, then reasonably believes facts that would negate the intent or the mental state for the offense, that's a defense to the crime.
That's
It
why
makes it a
in
non-crime.
In self-defense,
then-
you have to step into the defendant's shoes. It doesn't matter whether the guy intended the person any harm. What matters is whether the shooter reasonably believed that the person intended him harm. And in this case, this is either justifiable homicide, even though she was mistaken. It was either justified because a reasonable person walking through that door would have thought the same thing she did, or it was murder because she shot him with the intent to kill.
Okay, so then my question is it reasonable? And I'm just curious, I'm just asking. She parked on the wrong floor.
No, stop. Your premise of that question is already off. It's not whether, and I'm serious about that.
No.
It's not whether the
opening it
mistake
up.
is reasonable. It's if there is a mistake, is the belief from that mistake reasonable?
Okay.
The mistake doesn't have to be reasonable, just the belief from the mistake.
Right.
And you started off with, let's talk about the reasonableness of the mistake, which is not the right question
Okay,
to
Well,
ask.
and this is
that's what I was kind of getting at, because I think that's what I've been reading a lot online. That's what I was
did
going
Troy
to.
admonish you at the beginning? Do not believe everything you read online.
But that's what I wanted to talk about, because I think that the people that are watching are probably kind of reading. Not everybody's an attorney. We're reading these things that say she parked on the wrong floor, she walked down the wrong hallway, that there was this like doorstop that you can't mistake. Like there's no mistake. But say there was a mistake, is her response reasonable? And that's what I was trying to get at. And that was the purpose of the question.
As a person, and I had this happen a long time ago, I won't tell the whole story. I had somebody walk in the front door of my house with my family present, where I walked out with a gun and leveled it at them. And I had a shoot, no shoot decision. And thank God they backed off. It turned out being a homeless mental health patient who didn't know where the heck he was. But I was seconds from deciding whether to pull the trigger or not.
Not bad.
They're in the house, it's a threat.
I park in a parking garage every day, and I have to make sure that I'm careful to, as I'm getting on the elevator to leave the parking garage, remind myself which floor I'm parked on so I can find my car when I come back.
Right.
I don't find it terribly hard to believe that somebody could get turned around as to which floor they're on in a parking lot, especially if they walk directly from the parking garage and they're already on the floor for the apartment. And then from there, you're on autopilot, and you're almost counting.
Just
You're
at
almost
work.
just
I mean,
counting doors.
I'll go park on one of the floors of the garage at work, and I maybe didn't get enough sleep the night before. I'll come out at the end of the day, and I'm like, I don't remember what floor I'm on.
Or in the courthouse.
I'm gonna tell
in
you
the
a little
courthouse,
funny
if you're not
side
paying
story.
attention, you step off on the wrong floor. You go to the right courtroom. Only you walk in and you look at the bench. How did this? I'm not in the right courtroom, but I know I'm in the right place.
About 10 years ago, a good friend of ours, Doug Murphy, called me up one day. He was coming to pick me up. We were driving to San Antonio. And I said, I'm fixing to take a shower. Door's unlocked. Come on in. And fast forward a little while later, he calls me and he says, where are you? I said, well, I'm in my house. And he wasn't in my house. He was in the house that looked very similar a block away. He'd walked in the front door, rummaged through the refrigerator, hollered out my name, and we realized it wasn't my house. Of course, he left instantly. We still don't know this day whether they knew he was in it. Somebody else was in the house. Those things happen. The fact they're rare, the fact they're unusual, doesn't change the fact they happen.
Let me ask y'all this. I mean, there's been, obviously, you're getting a lot of stuff in the media about whether there was reports of whether they were dating, they were, all this stuff, whether she has some judgment issues in her past on the job and everything. She may have been involved in another incident. We don't know which of this is accurate, but we've seen the firestorm that this has created. What if the role was reversed? What if he shot her?
It would have been just as justified, in my opinion.
But he would have been lucky to survive. He would have been lucky to survive the encounter with the responding police, because all they would have known is there's somebody in uniform laying there on the ground bleeding out, and this is the guy that did it. If he survived the initial encounter with the police who responded to the initial shooting, he would be exonerated.
You know what that
That's a
brings
really fair point. That's a really fair point.
If I were someone who cared about him, that would be my initial concern, is whether he was going to survive the cops who showed up to deal with the cop killer.
That brings up a side issue, but a very important point. Merely because there is someone who has been shot and killed, and it is a tragedy. A life has been lost, apparently a very valuable, I value life, but a very valuable life, apparently a very good guy. Merely because there's been a tragedy does not mean there's been a crime.
Yeah.
And it would be true regardless of which way this went. If he had shot her and she had died as a police officer, people would be screaming cop killer. Merely because there's a tragedy doesn't mean there's a crime, and that's such an important thing to remember that gets so lost, especially in the public fury over which side people are on. Not everything that's a tragedy is a crime, and we need to remember that more often.
And people shoot non-threats in self-defense situations. I'm not going to say all the time, but often enough that when you're studying self-defense, they teach you very clearly the question is not whether the person intended you harm. The question is whether the shooter thought that harm was intended,
perceived it.
and that thought was reasonable when the situation is viewed from the defendant's. You step into the defendant's shoes and ask, was it reasonable for the shooter to think that this was a dangerous situation?
A few years ago, the district attorney's office allowed several groups of defense lawyers to go into the shoot, no shoot simulators where we had a gun hooked up to a cable and scenarios played out where we had to make a decision on whether to fire, not fire, who to shoot and who not to shoot. And I went into that thinking, oh, this decision's easy. Things are going to be so, it can't possibly be that difficult. I had that preconceived notion. I shot innocent people. I got killed because I didn't react quickly enough. And until you've been in the situation, until you've seen those things, it's very hard to appreciate the literal split-second decision that people make based on how they perceive things. And looking at things in hindsight is always 20/20. You can always second guess. But when you've got a split second to make that decision, hindsight's not a luxury you have at that time.
Yeah, it's just like eyewitness testimony.
And I completely understand that. I trained with those simulation systems, and I thought that I would do an impeccable job, because I always do. Turns out I shot everybody because I was just so amped. And it's not even, like, it's a real gun, but it's like hooked up to a cord, so you don't even feel like you're in a real situation, yet I literally shot everyone.
You have less stress in that situation than you would in a real situation.
Oh, no, I shot everybody, and they were, the first time up, I can tell you, I shot everyone. They're like, what are you doing? I was like, I don't know, I'm shooting everybody.
Mowing them down.
I'm not going to get shot, was like kind of my thing. But through training and experience, of course, I stopped shooting civilians. And that's an easy thing for me to say because I was never in her particular situation, but I think it goes back to, I think what we're seeing, the bigger picture is not, and I'm not taking anything away from maybe inherent racism and things, those types of issues, but just training in general on officers. My dad was a cop. He was a cop for 30 years, and hearing kind of the training he went through, knowing the training I went through in the military, seeing the training that the officers are going through, it's not sufficient these days. And I think, I don't want anybody to misunderstand what I'm saying as far as I think there is really inherent racism issues happening. But on a bigger level, I think there's training issues. There's simply training issues happening.
I said this the last time I was on this show. One of the biggest problems we have in our society with our police is that we train them to be afraid of us, and we've convinced ourselves and we've convinced them that they do the most dangerous job on the planet, and that they're far more likely to be killed by one of us than they are by wrecking their car without their seatbelt on. Neither of those things are true. But the result of it is that we have a police force who largely is being trained, shoot first and ask questions later. If you feel any subjective threat, resolve the threat with your firearm, and we'll deal with it on the back end. And with respect to your comments about her training, as I'm trying to picture how this could have gone down, my guess is she was well inside the apartment before it clicked that something's not right. And the thing that clicked was, from the reports that we're seeing, sounds like when she saw a man much bigger than her in what she thought was her apartment approaching her. And at that point, I think her police instincts did kick in. She probably told him to stop. And when he reacted in confusion, instead of stopping instantly, she pulled out her gun and shot him.
Well, and I think you make a really fair, sorry, I don't mean to interrupt you, but I think you make actually a really fair point on the difference. So I wasn't trained as a civilian police officer at all, so don't mistake that. It was military, where, despite what you hear, we are very much trained to try to de-escalate if we can. Much of the time I joined right after 9/11. It was urban warfare, and so you're trained to de-escalate if possible. I know that kind of goes against some of the things that are reported, but we really are trained to de-escalate. If you walk into a situation that looks bad, take cover, shoot last. Where I think you're right, civilian police officers are, whether it's intentional or not, I think they're kind of being taught to be afraid of us, that we are the enemy, and it's not as instinctual to take that back seat. Maybe I'm wrong. Maybe we're making overgeneralizations, but I think there's something there to your comment.
There is a huge amount of research that shows that under stress, and it doesn't matter whether it's police officer or anybody else, the higher the degree of stress, the greater the degree of threat, people end up getting very close tunnel vision. Mm-hmm. Extraneous factors that you look at after the fact and think, oh, somebody may have seen or considered this, those don't become realistic choices. It's the fight or flight reaction, mm-hmm. and you truly get real close-in tunnel vision where you're focused just on this threat, to the exclusion of all the details that, if you have time to sit back and think about it, you can appreciate differently. But in that moment, they get processed in a far different way than when you have time to sit back and think about it after the fact.
Right, and
Absolutely.
she would not have seen that this apartment was decorated differently than hers, or that the furniture was laid out differently than hers. She walked through the door, someone that she was not expecting to be there was there, and from that moment forward, for at least the next several seconds, he was all she could see. And she wasn't seeing all of him, but we talk about witnesses to robberies or victims of robberies and weapon blindness. The only thing that the victim of that mugging saw was the weapon. Didn't see the face of the guy holding the weapon. That was the only thing they could see. And so when she walked into this apartment and sees this guy who, to her mind, shouldn't be there, until he was lying on the ground bleeding out, he was all she could see. And by the time she figured out what had happened, it was too late to fix it. And it sounds like from some of the other witnesses that, moments after the shot, she's on the phone calling 911. She's telling him, I'm so sorry. She realized her mistake by that point, but that's not going to bring this guy back.
And that's what I was going to point out, is from all reports, she immediately tried all first responder medical that she needed to do, immediately called 911. So I was going to...
I want to bring this back first, full circle where I started with, which is that a lot of the judgments we're making about this are based on woefully incomplete information at this point.
Wild speculation. It's my favorite thing in the world.
This may turn out going many different directions. This is a marathon, and we're in the first 100 yards at this point.
Absolutely.
And there may be lots of other things we don't know about, and our judgments about these may change. I just encourage people, don't rely on media reports for the truthfulness of the facts, because so much of that is incomplete. There's not all that. There's some that's just wrong, but a lot of it may be literally correct, but out of context. Don't rely on media reports for the truthfulness of things like this.
Yeah, like I said, there's just been so many crazy reports coming on this case that you don't know what's true. This idea that they were in a dating relationship, then people were like, no, they're not in a dating relationship. It's gotten out of control. Really.
Most of those things appear to have been debunked already.
Right.
And I emphasize appears to be.
Yeah. Well, some of the dating relationship, and the family would have known. The family was, I think, a little far removed from his everyday life.
Well, from what I've seen, it sounds like very shortly after the shooting, somebody went and scraped his social media site and found a picture of him posing with a girl who looked kind of like her, but not all that much like her.
It turns out not being her.
And just jumped to, oh my God, these people knew each other, there's more here. And it's beginning to look more and more like this was a terrible accident. But no matter how you slice it, I don't see how you get to manslaughter. This wasn't recklessness. She intentionally shot him to death. The question is whether that was justified or not.
Well, and I think that you brought up kind of something that I've seen a lot in the reports that I don't think everybody maybe understands is, oh, this is murder. Well, then they just charge her with manslaughter. Kind of what's the difference? And I think with that question, what else I'm asking you is, In some other cases we've seen, they've overreached on the murder charge.
Yeah.
Right.
And this one,
these
I
days,
think they're
like,
trying to,
Look,
back down
she-
on it.
if
Kind of
she was-
explain that to us.
If she was not a police officer, I don't think she would be charged yet at this point. I think that the investigators, from the brass at Dallas Police Department to the Texas Rangers to the DA's office, all of whom are involved in this charging decision, I think they were all left in a position of feeling like, well, crap, we can't do nothing, but she's one of ours. We don't really want to charge her with murder. We can see how this happened and that it was an accident. And so they decided to split the baby and charge her with manslaughter because it sounds good for the press. The press feels like they are doing something about it. But the reality is, if this had been you or me, it is almost certain that we would have been interviewed and we would have been told not to go anywhere, but I don't think they would have arrested or charged us with anything until the back end of the investigation, unless, of course, the person lying on the ground was a police officer, in which case we would have been beaten to a pulp and charged with murder on the
Well,
spot.
am I incorrect in saying the Texas Rangers actually said not to issue the arrest?
Well, they said hold off.
They hold off,
They said
yeah.
they said we should hold off, and I think Dallas Police, for public relations reasons, said we can't hold off.
And
We
even
have to do
more,
something.
I'm wondering how any judge, based on this probable cause affidavit, found probable cause to believe there's manslaughter. You
Troy,
can't find that from the face of this affidavit.
You've been doing this for long enough to know that doesn't matter. I could show you some affidavits. I mean, the
Let me
reality is,
rephrase that.
an officer
Any
showed
judge
up.
could honestly do that.
Right. No, there's no probable cause here for manslaughter. I don't see any version of facts, unless she's saying that she pointed the gun at him and it accidentally went off. I don't see how you get to manslaughter on these facts.
I agree.
Yeah, I don't either.
Assuming the facts are true.
Right.
We only got a minute left.
Well, I guess Manafort's going to wait for next time,
He's gonna have to wait for next time.
which is probably good because we don't really know much about that yet. Anyways.
Well, we'll know more about the actual.
We know less about that than we did about
Yeah,
this.
I mean, we'll know a little bit more. All we know is he's contemplating a plea agreement
Yes.
with the special counsel's office. Guys, I appreciate you being on the show.
Thanks for having me.
We've got, starting next week, we're going to be featuring the candidate shows again. Woohoo!
Knock on wood.
Yeah, no kidding. We'll see how it goes. We're going to be lining up some of the judicial candidates to come in. Do you guys have any thoughts, quickly, we got about 30 seconds, but anybody want to chime in on what they think some races to watch here might be?
It's all going to be about the turnout.
Yep.
That's what it's going to be about.
Yeah.
I mean, it's the top of the ticket will decide almost every judicial race, at least for this election cycle. That'll end for the next one, but for this election cycle, it's going to depend on who can get the most people out.
If the Democrats turn out, Democrats will win. If they don't, they won't.
Probably come down to this Beto versus Ted Cruz. That's going to bring the people out.
Could very well.
That's all the time we have for this week, ladies and gentlemen. Kate, I'm glad you could join us this week.
Oh, well, thank
Step
you
in
for having me.
and fill in
Yeah.
for my beach-going Norman
Yeah,
coach.
where is JV? You got to get him back next week.
No, we'll try to get him back next week. Hopefully he can get in here and get back to work on a volunteer basis.
I think he had a libation excuse.
Oh, good point.
That was his excuse. He's probably sipping a drink with an umbrella in it somewhere. I want to thank our guests, Troy McKinney and Jordan Lewis, for joining us. For Kate Farrell, I'm Jimmy Ardwan. We'll see you next week on Reasonable Doubt. Thanks. Good night.